I'm going to say something that's controversial. And the controversial thing that I'm going to say is not everybody needs a will. I'm an elder law attorney. I also do estate planning work, and this is blasphemy in the estate planning world. But I'm going to say it again. Not everybody needs a will. Let me give you an example of someone who doesn't need a will. If you are someone who has one bank account and you own a piece of real estate, I would suggest to you that with a little bit of advanced planning, you could avoid having to go through the probate process. Because that's all a will is, right? A will is saying who gets your stuff, and in order for the person to get what it is you want to give to your heirs, they have to take your will, go to court, hire a probate attorney, and get a judge to confirm that this is the right will and that this is where you want things to go. That can be time consuming, and you also have to pay a lawyer to do that. So if we can avoid going to probate, that's always I believe, a preferable route to go. Now, just because you don't need a will doesn't mean it's still not a good thing to have, and we'll get into that in a second. But again, so let's go our example. I have someone who's got a bank account and they have a house or a condo. All right, you can walk into the bank and list one or more pay-on-death beneficiaries. And if you do that, whatever the bank has in their records will supersede what you put in a will anyway. So if you walk into your bank and you meet with the bank officer and you say, I want to list my children as the pay-on-death beneficiary of everything that's in my bank account, after you pass away, your kids will be able to go to the bank with your death certificate and they'll be able to gain access to those funds. Okay? All right. And now if you have this real estate, I would strongly suggest you go to an elder law attorney, whether it's myself or someone closer to you or whoever it is, and you record what's called a ladybird deed. And a ladybird deed, and I'll link to another video and article that talks more about it, but essentially it's the equivalent of a pay-on-death indicating a pay-on-death beneficiary in your own deed that you record in the public record. So with a properly executed and recorded ladybird deed, it's now in the public record, and the deed says who gets the property after you pass away. Your heir or heirs need only record your short form death certificate, and then they would automatically own the property as well without having to go through the probate process. Now, so if it's a simple case like that, I would argue that that person doesn't necessarily need a will. Now, why might that person want a will anyway? There are a couple of reasons. Well, the first thing is the reason why, even if you have a bank account and real estate, you still might want a will, is if you have someone that you specifically want to disinherit, right? Let's say you have a child who you think, for whatever reason, you don't want this person to inherit what you have. It's good to have a will that specifically says, it is my specific intention that this person or persons don't get anything of mine, so that they can't call into question anything that you did earlier. So if they want to open up a probate on your behalf, they'd be out of luck because there would be a will that someone else would produce that would say, no, I'm sorry, there was no mistake here. The deed was filed properly and the bank accounts pay-on-death beneficiaries were written out properly. We specifically have in writing here, you're not to get anything. So that's one reason. Another reason is to provide for multiple contingencies, right? So let's say you record a ladybird deed, which is really good at naming one or more people to receive your property after you pass away. But the question becomes, what if those people predecease you? What if they die before you? Well, then you'd have to open up a probate anyway, because now their portion of whatever it is you wanted to give to them, whether it's through the real estate, through the ladybird deed, or the pay-on-death portion of the bank account, now it gets more complicated because their estate will now control what happens to their portion of the proceeds. So to prevent something like that happening, instead of a ladybird deed and a pay-on-death beneficiary on a bank account, we would suggest utilizing a revocable trust, also called a living trust, also called a revocable living trust. These are all terms that mean the same thing. So instead of the bank account being in your name, we'd put it in the name of a revocable living trust that you have full control over as if it was in your name alone. And then after you pass away, it indicates who controls and what should happen. And you can utilize a revocable living trust for your real estate and for your liquid financial assets like bank accounts and stocks and brokerage accounts and things like that. And that way you can provide for these multiple contingencies if these, while we all expect to outlive our children, it doesn't always work that way, and it's nice to keep that money in a trust, because if you have minor children, you can provide for what happens in that scenario. If you have, one child predeceasing the other, we can save that child's half for their heirs, or you can have everything go to the other child, right? It's infinitely malleable and flexible in a way that just utilizing a ladybird deed or a pay on death beneficiary just simply is not. So I hope this has been informative. If you're interested in having an estate planning consultation with an elder law attorney in Florida, please give us a call, go to visit our website, and I'd be happy to help. Thank you.